Hi, I'm Janice Switlo, and a number of Anishinaabe had asked me to provide more explanation and background as to the Section 35 domestic doctrine. And in March 6, 2019, I responded in writing. Now, I only had a couple of days to get this together for them because, they were having, elders were gathering and ceremonies and such, and they wanted to consider these words in their gathering. So what I don't read from something when I speak to people. As people can attest, I can go for hours and days, and I don't hold paper. But today I'm actually going to read from this document because it contains some very important history regarding the Section 35 doctrine that most people, to my knowledge, are not aware of. And this also sets the stage for my continuation on discussions regarding the J Treaty and various elements of how Canada is proceeding to try to eliminate those from whom permissions have been granted. So the Section 35 Constitution Act 1982 domestic doctrine was created by Justice Antonio Lemare. No lawyers appearing before the Supreme Court of Canada have presented arguments supporting what was created. Justice Lemare threw out the arguments before the court and substituted his own doctrine. Now, later down here, I explain why the Section 35 doctrine is bad law, put in place unlawfully and unconstitutionally with the explicit purpose of effecting the conquest of the Indigenous nations, usurping their land, resources, and sovereignty. Lemare amended the Constitution of Canada, which he had no power to do. The court is limited to interpreting a provision that's written in a constitutional document that is unclear, and does so by looking to the intentions behind what was written. The court cannot amend the Constitution. The court cannot say, this should have been written in the Constitution, so I'm going to write it in. Not, that is, in a democratic, rule of law abiding nation for whom the Queen remains the head of state. Now, Justice Antonio Lemare was nominated directly to the Court of Appeal of Quebec by Prime Minister Pierre Trudeau. Now, justices usually have to work their way up from appointments first to lower courts. After only 2 years on the Court of Appeal of Quebec, from 1978 to 1980, Lemare was nominated by Prime Minister Pierre Trudeau to the Supreme Court of Canada and appointed March 28, 1980. He became Chief Justice of the Supreme Court of Canada on July 1, 1990, and he retired January 6, 2000. After he retired, Lemare then served as Communications Security Establishment Commissioner. Now, the Communications Security Establishment is the Government of Canada's national cryptologic agency administered under the Department of National Defense, responsible for foreign signals intelligence. Before he was appointed to the bench, Lemare served in the Royal Canadian Artillery from 1950 to 1954 and in the Canadian Intelligence Corps from 1954 to 1960. He graduated in 1956 from the University of Montreal, as did Pierre Trudeau. Now, in 1980, just a little bit of background so you understand where this person who was responsible for inputting this absolutely unconstitutional change in the Constitution of Canada, and for the purposes explained. Here's a little bit of his attitude to think of. In 1982, Justice Bertha Wilson was the first woman to be appointed to the Supreme Court of Canada. Justice Lemare refused to rise from his chair when she entered the room for her first judicial conference. This was a tradition that always happens when a new judge appointed to the Supreme Court of Canada enters their first judicial conference. That's when all the judges get together to discuss matters, usually cases and distribution of cases, etc., sometimes those decisions. The first one she entered, he was the only person who remained seated and insulted her in that manner. Now, I attended a little bit of my background, put this into perspective. I attended Osgoode Hall Law School beginning in 1983 and graduated in 86. So this was a big deal, first female Supreme Court of Canada justice. But we were never told about this disrespect accorded her by Antonia Lemare. I was called to the bar of BC in 1987. I practiced in the private sector until I joined the Department of Justice in 1989. There I served as in-house legal counsel for Revenue Canada Taxation, Customs and Excise, and then later was moved over to be in-house for the Department of Indian and Northern Affairs, as it then was. So I advised on all lands, revenues, and trust matters, and final land claims, specific claims, and cutoff claims. And at one point, I was the sole representative for Canada at the Nisga'a land claim table, specifically on self-government. I was known nationally within government as the expert in water rights and as very knowledgeable on Crown duties. Other Crown lawyers would regularly travel to Vancouver, where I was based, to ask my opinion before giving their advice. And the most senior Crown lawyers would call me to Ottawa. While I remain subject, obviously, to solicitor-client privilege, my knowledge gained there remains mine, shaping the warnings and strategy I provide. Now, I practiced law and maintained my membership in the Law Society of British Columbia until 1997. Unfortunately, I was in two near-death motor vehicle accidents in 1995 and in 1997, which seriously affected my health. I was unable to carry on my legal practice under Switlo & Co. This was as a passenger, so this is why I no longer accept offers of rides and insist on driving myself. I remained called to the bar, and I became a member of the International Bar Association in 1992, and I maintained that membership until I moved to California in 2009. I returned to Vancouver in 2015. So getting back to the Constitution Act 1982, the version signed by the Queen, Section 35 is not within Part 1, the Charter of Rights and Freedoms. The Charter only applies to Canadian governments. This is why in every final land claim settlement agreement capitulation bringing Indigenous people beneath Canada, there is a clause that says the new legal entity created by the federal government in implementing the agreement is subject to the Charter. Section 35 is contained in Part 2, and at the time the Queen signed, it read as follows. Subsection 1, the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. And subsection 2, in this Act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis peoples of Canada. Now, as noted constitutional expert, legal expert, Professor Peter Hogg pointed out at the time, with Section 35 being excluded from the Charter, and I emphasize this, Section 35 cannot be limited by Section 1 or the notwithstanding clause. Section 1 of the Charter reads as follows. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So Justice Lemare, key to Prime Minister Pierre Trudeau's plan, amended the Constitution of Canada by creating a Section 1 equivalent within Section 35. The Section 35 doctrine provides for the quote-unquote lawful way to finally push aside, even completely, the quote-unquote beasts of the field. So you can see the attitude of Justice Lemare towards women. He relied on the doctrine of discovery for his Section 35 doctrine. The only thing required in order to push the beasts of the field aside is to give notice, consult, and sometimes pay some money. That's called accommodation. They can be pushed aside even to the point of infringement of the Aboriginal rights as defined by the Section 35 doctrine, to the extent of not being able to exercise the so-called rights at all. Constitution Act 1982, which Lord Denning said, hey, to the chiefs who visited England, no worries, it cannot undermine the status of the nations and the relationship with the Crown. It was actually unconstitutionally amended to do just that. The court developed a test to limit Section 35 that Professor Hogg has compared to the Section 1 Oakes test. Professors Ted Morton and Rainer Knopf, despite their criticisms of charter case law and growing judicial discretion, treat Section 35 as if it were part of the charter. They say, quote, Section 35 is technically outside of the charter, but as a declaration of the special rights of Canada's most salient racial minority, rights that are enforceable in the courts, it has become an important part of the charter revolution. The nationals of Indigenous nations are not domestic ethnic minorities within Canada. That is, however, the goal. The prime instruments of achieving this final capitulation include litigation under Section 35, final land claim settlement agreements, and a multitude of agreements that together can evidence that Indigenous people do indeed see themselves only as a domestic ethnic minority, and the ancestors who signed treaty were not fully human, and it was right to treat them as subhuman, quote, beasts of the fields, end of quote, whose lives were, quote, nasty, brutish, and short, end of quote. The end justifies the means, even if the means Canada is an outlaw nation raising its middle finger at the rule of law. Now, right after, I'll get to that point, that area in a minute. I'm just skipping a little bit here for ease of timing. I review that as the following reflects, it is even seriously questionable as to whether the Supreme Court of Canada itself is actually constitutional. Valid. Never mind not having the authority to amend the Constitution of Canada. Quote, there has been a debate among legal scholars as to whether the Supreme Court of Canada is entrenched in the Constitution of Canada. The Supreme Court of Canada was not created by the Constitution. Rather, the power to create a, quote, Court of General Appeal for Canada, end of quote, was granted to Parliament by Section 101 of the British North American Act, 1867, which of course is now called the Constitution Act, 1867. Parliament proceeded to create the Supreme Court of Canada under the authority of Section 101 in 1875 by passing the Supreme Court Act, which was an ordinary piece of legislation with no constitutional significance at the time. The Supreme, continuing with the quote, the Supreme, because this is not my analysis, I'm quoting this, it's a good summary of the debate around the constitutionality of the Supreme Court of Canada. The Supreme Court of Canada was mentioned for the first time in a constitutional document by the Constitution Act 1982. The Supreme Court is referred to twice, and I won't get into the specifics, but it's in sections 41 and 42 of the Constitution Act. Thus, it appears to include the Supreme Court of Canada in the Constitution of Canada. However, this conclusion is questionable because the Constitution of Canada is expressly defined in section 52 sub 2 as a set of 30 instruments that does not include the Supreme Court Act. Some scholars, including Professor Peter Hogg, who again is recognized as a preeminent constitutional expert in Canada, have suggested that the references to the Supreme Court of Canada in sections 41 and 42 are ineffective. They argue that these references are, quote, anticipatory, end of quote, and will become effective only if Parliament adds the Supreme Court Act to the list in section 52 sub 2. Other scholars, including Professor Cheffins, and I don't know him, have argued that the Supreme Court Act is implied as entrenched into section 52 sub 2 because of sections 41 and 42. Section 52 sub 2 uses the words includes to introduce the list of 30 instruments, suggesting that the provision does not contain an exhaustive list. The Supreme Court itself has confirmed in New Brunswick Broadcasting Co. versus Nova Scotia, Speaker of the House of Assembly, that's a Supreme Court of Canada decision from 1993, that section 52 sub 2 is not exhaustive, but has not yet ruled on whether the Supreme Court Act is included in the Constitution of Canada. But here's the problem. I appreciate that's an old act. Why wasn't it included in the list if that was the intention? It would easily could have been done. How can the Supreme Court of Canada answer and rule on whether the Supreme Court Act is included in the Constitution of Canada, appreciating the difficulty in law of a body being questioned as to whether it constitutionally exists, whether it has any constitutionally valid jurisdiction at all, thus deciding whether it constitutionally exists? I mean, it's a classic catch-22 situation. So the above that I've described, and plus many more actions on the part of the federal government, and more recently the governments of provinces, is why I say Canada is an outlaw nation. Now, in the course of trying to get full ownership and control and whole Crown sovereignty, instead of complying with its constitutional position beneath the actual owners, the nations, the Indigenous nations, with Crown having partial political sovereignty with the permissions granted to the Crown by the nations by treaty, the whole of the Crown's interests are put at risk, never mind the matter of the honor of the Crown. Now, these actions constitute threats against the peace, in my opinion, and for details on that, I refer you to my 2015 ebook, Appleseed 2.0. That's available online. So right after the Queen signed into effect the Constitution Act 1982, the Canadian governments effected the Constitutional Amendment Proclamation 1983, and they amended Section 35 and Section 25. Now, for the interest of time, I won't get into the particulars on that. But they basically put that in and said, oh, this is just, another of these 11 minor amendments to the Constitution since it was patriated in 1982. And most of these amendments have been limited in scope, dealing only with matters affecting specific provinces. It is not minor to try to change the status of nationals of nations with whom the Crown has entered into treaties that remain binding on the Crown into a domestic ethnic minority. That's an act of war, an attempt to conquer, a threat against the peace. Only the Crown, only the Queen can declare war. She retains that prerogative. She has in place, as a limit to her sovereignty, however, a relationship by treaties that she cannot exit. What she cannot do, her governments cannot do, either directly or indirectly, and certainly not unlawfully and unconstitutionally. The Queen has treaties with the nations which are matters of international law. She does not have domestic land claims agreements. She would not have signed something that changed, that those amendments I should have mentioned that happened right after 1982 and 1983, they added in land claims agreements. She wouldn't have signed anything that pertained, that had those things in there. I don't even think she really understands or realizes that this has been the approach of her Canadian governments. So since the Crown is under a duty of fairness, she must deal with the nations consistently. This means by treaty. If, however, the nations capitulate, or worse yet, agree they were never human, so could never enter into treaties, so the court calls them sui generis, domestic agreements, which is ridiculous, since the Crown by treaty recognized the nations and their sovereignty and decided to obtain permissions by treaty instead of going to war with them. There is no exit provisions in the treaties. I need to emphasize that. The only way for the treaties to fall is if there are no more nations party to the treaties having abandoned and agreed. They are merely domestic ethnic minorities subject to begging. So it's either nation to nation, Crown bound by treaties and her permissions allowing for her partial political sovereignty to be exercised in the lands of the nations, or doctrine of discovery, beasts of the field, and assertion of Crown sovereignty. That's the old plant the flag deal. Passing off land claim settlement agreements negotiated under federal policy as being treaties, which they are not, amending the Constitution of Canada to create the Section 35 doctrine, mimicking language to appeal to Indigenous nationals who do not truly have independent legal advice, avoiding the Crown duties, including as stemming from the Royal Proclamation 1763 and the duty of fairness, triggered once the first treaty was entered into by the Crown and an Indigenous nation. That is not only unlawful and unconstitutional, but also an outrage and triggers application of some very serious international law. Now, no lawyer can comply with their oath by building upon the Section 35 doctrine and thus misrepresenting the legal status and nature of the nations. Now, remember, I wrote this before I found out that BC lawyers had changed their oath to the Crown. So here's another aspect of perhaps why they found it necessary to change that oath. Lawyers in compliance will act to remove this bad law, not reinforce it. But I have to remind, too, that lawyers are also acting on what's being said to them by their clients. So, everyone's around saying, I have not been consulted, instead of saying, we have not permitted this. There's a distinction. So, no lawyer in this duty and age can directly or indirectly, by reliance on the Section 35 doctrine, say the doctrine of discovery is good law. No scholar or lawyer not influenced by the systemic racism that prevails all Canadian systems and the indoctrination that besets Indigenous nationals who have been subject to all manner of continuing attempts to colonize and conquer them can allow for unconstitutional amendments to the Constitution of Canada. There are, of course, consequences to standing for the protection of nations, for the principles of the rule of law, which in my case have included threats against the life of my child, offers of great sums of money to, just go buy an island somewhere and just leave Canada, something that I describe as economic application of the economic death penalty, which I will get into in another session, smear, defamation, and of course a slap lawsuit. So I leave you, though, with this thought. When he arrived among the Haudenosaunee, sorry, I'm a bit tired today, the peacemaker taught, if you take one arrow alone and try to break it, you can easily do so. If you take 5 arrows bound together and try to break them, you can never do so. So, if you 5 nations are bound together in one confederacy, no one can ever break you. I have had to stand alone, and yes, I have had to pay for that personally, as one judge informed me in court would happen. But you don't need to stand alone, and you need to have no fear. The Anishinaabe have been told, don't worry about the deals they're going to enter into, because, if anything else, don't worry. Section 35 will save us. Section 35 will not save you. It threatens you. What the ancestors did to provide for you will protect you. Continue to carry, as they did, from those before them, so as to provide for those to come. Those, my friends, that's the background of Section 35. It is not your savior. It was put in place in a deliberate plan to effect your termination and to render lawful a doctrine of discovery and to build upon that. Aspects of law that in really any other field would never be tolerated by lawyers practicing in that. And that's all I have to say.